We'll now recognize the gentleman from California, Mr. Issa, for 5 minutes.
Thank you, and I really appreciate the testimony of my colleague from California, since it looked like it was testimony and nothing more. You know, the interesting thing is that that oath he talked about, every state employee in California takes a similar oath. And the odd thing is the district attorneys take an oath to the California Constitution and the United States Constitution, which means that they understand that sanctuary city law is unconstitutional, that it's wrong, and that interfering with federal employees trying to execute, in fact, would be a conflict of their oath. So I know the gentleman means well, but, you know, people sign oaths. How many take it seriously? And the answer is not nearly enough of our federal employees. Just yesterday, we dealt with the recognition that some people at the FBI, either agents or staff, had willfully disclosed ICE's actions in a way that could cause them to be shot or killed by the MS-13 people they were attempting to round up as both criminals and illegal immigrants. Oaths are a wonderful thing, but with all due respect to my colleague who's left the room, let's talk about faithfully executing the Constitution. Mr. Smith, on the subject that we're here for, are you aware that the Federal Trade Commission has nearly a 100% success rate in their administrative court?
Yes, certainly.
Are you aware that even if an administrative judge were to not find you guilty, so to speak, that the commission can overrule that and basically make you guilty?
Yes, and I believe they do almost all the time.
Are you aware under the last 4 years of the Federal Trade Commission, they had far less than a 50% chance of surviving if they went to a federal court with a judge and a normal process of due process?
I believe that.
So the reality is you've got a kangaroo court at the Federal Trade Commission, and with all due respect, it doesn't really matter who's in the White House. The Federal Trade Commission has asserted its authority far beyond the intent of Congress.
I agree.
Now, in your case, you struck a chord with the Supreme Court. Basically, the recognition that when they start getting into constitutional issues, they don't have that right, period, that the Article III judges do have that right, and you don't have to exhaust all of the kangaroo court procedures before getting to the Article III court. Is that true?
It is, yes.
But let's ask the question for you and the others here. Wouldn't we be better off if, knowing that the Federal Trade Commission is not faithfully executing the intent of Congress, the statutes, and the Constitution, that you didn't have to wait and spend millions of dollars and perhaps lose an acquisition, and you were simply able to go to where you have a right, which is the Article III judges themselves, if it's a federal law?
100%, yes.
Here's the last question, and I'd like each of you to opine on it briefly. The REINS Act attempts to say for major regulations, is there any reason that any of you can find that Congress should not be able to, at any time, by a simple vote, second guess, in other words, second guess a regulation that has been made by an agency that says it's the will of Congress, but in fact cannot substantiate that it is? And bearing in mind, the same numbers that it takes to pass a law are the same numbers it takes to object to a regulation. You, Mr. Smith, first.
Seems reasonable.
Ms. Wade?
Likewise, seems reasonable.
Doctor?
Yes.
Give you a shot.
Absolutely. The REINS Act, yes, I agree.
Yes, sir.
I mean, I think there's a longer conversation to have, Congressman, about legislative vetoes after INS versus Chadha. I think, I mean, one of the things that I'm struck by is I don't know.
Well, wait a second. I was asking a more narrow question than a legislative veto. If, in fact, regulations were considered by Congress de novo, and they simply said, will we support that regulation? It's not a veto if you ask, is that regulation consistent with Congress? And you go through the process of the House, the Senate, and the White House. Is there anything inherently wrong
I'm
with
sorry,
that?
Congressman, I misunderstood. I thought you were skipping presentment. No, of course, Congress can do anything to overturn a regulation through bicameralism presentment.
Okay,
I wish
and-
Congress would do it more.
Right. And now, Doctor, I'm going to close with this very briefly. If, in fact, Congress doesn't have the will to sustain a regulation, effectively holding a vote and not getting a majority would be the equivalent of saying we don't want that law. Isn't that correct?
That does sound correct, yes, sir.
Thank you. I yield back.